Right, good morning, everybody. Welcome to the second webinar hosted by Consumer Friend. I'm just waiting for all the attendees to join. So just give us a couple of seconds just to get everybody on board. Okay, the number is rising, so just give us a couple of seconds.
Oh, no.
Right, I think let's just kick off and then everybody can join as and when it comes off. So everyone, guys, welcome to the second webinar hosted by Consumer Friend. Day 125, I think it is, of the national lockdown. I think I'm over it as much as what everybody else is. And I'm missing everyone's faces from the number of people that I actually see that are attending. So once this whole apocalypse is over, or at least die down a bit, at least I'll be able to come through and see some guys. But until that happens, this is what we've got to do. We've got to have little webinars like this. So what we're going to be chatting about today, I think, is one of the important aspects within debt review, and that's the sort of large, big milestone stage, and that's the legal process. And I think the best thing for us to chat about there is to say, okay, which route does the consumer take? Does the consumer take the Nct process? Does the consumer take the magistrates court process? And I think what needs to be discussed there is the importance that this protection gives all parties involved. I think there's protection involved from the consumer's point of view, and that they've officially been declared over indebted. They've now have a debt restructuring proposal in place. And I think it also affords protection to the credit providers in that they understand exactly what needs to be met, what the consumer needs to meet, and they can keep an eye on that. So I think in discussing that, what we're going to do is we are going to also just have this webinar a little bit differently to how it normally runs. And I encourage you guys to please put through some questions. We are going to have a question and answer sort of session throughout the whole process. So I encourage you guys to please pop questions on here. It's going to be a live answer session, this webinar, and I think that's great. Those questions perhaps that our panel members perhaps can't get to, or if they need to do some research, perhaps we'll give them the opportunity to actually do that, and then from there we will then send the answers off through to you. What we'd also like to do is there will be a couple of polls that you'll see pop up during the webinar. I encourage you guys to please participate. It'll give us some nice stats. So this is not a parliamentary sitting, so I don't want you to use your power to abstain. I would like you to please form part of it, select some of those questions. I think there's only 4 polls in total, so if you can just participate on that, that'll be great. It'll give us some nice information. Before I introduce our speakers, I'm just going to give us some stats on what we're chatting about today. So as you guys know, we do predominantly a retail section. We have a lot of loan-based products, credit card-based products as well. And what we're going to, and what I thought will be interesting for me to share with you is how many people that have entered debt review actually end up at the court order granted stage. And then also those consumers where an application has been lodged at court or at the NCT, how many of them actually get a granted order at the end of the day. And what we found is those people that actually enter the debt review process, only about 30 to 40% of them actually get a court order in place. And that's a scary stats. You know, I've chatted to other people, they have about the same numbers. So there's obviously things that are happening to consumers where they're not able to progress through to the final stage, whether it's terminations that happen, change of circumstances, or whatever it is. So I think it's important that we address that to find out why consumers aren't going through to the final process. And then again, the second stats that I actually pulled here are those matters where there's a application that's been lodged at either the NCT or at the MAJ court. We're only finding about 45 to 50% of those consumers are actually getting a granted order in place. I would have thought it would be a lot higher. So there's obviously things that are stopping consumers from once the application is lodged at court or at the NCT to getting the final order in place. And I think that's the chat that we're going to have today with all the panel members, is to discuss what these difficulties are. So I'm going to kick off with our first speaker, which is Derek Benderman. He is an attorney from Benderman and Associates, and he's been in the industry for ever and a day. You know the name. I'm not sure if you know the face, but you can now put a name to the face. Derek, can you hear me? Let's just unmute you there if I could. Yeah, there we go. Derek, can you hear me?
Justin, I can hear you. Can you hear me?
Great. Thanks so much for joining us, Derek. I know your time is precious. So yeah, thank you so much for being part of this.
Only a pleasure.
Thanks so much. So Derek, I think to start off with, before we get into the nitty-gritty of this, if you can give us sort of the average day in the life of Derek Benderman. You get an instruction from a dead counsellor for a matter to go to court. Assuming everything is drafted, all the paperwork is ready, how does that process unfold at court? Just to give the dead counsellors out there some sort of indication, those who perhaps don't have their finger on the pulse at the actual court process.
Guys, thank you. I'm just going to start. Courier stops at my front door, drops off an application, copy and original. So the first thing that we do, obviously we open a file. I just want to see what this is. Which legal process do you use? I just want to take that.
That's just a poll that I've put on for our listeners, just to have a quick vote. But we'll chat about that a little bit later, Derek. You can.
Okay. So I received a copy of the original. We open a file, and then the most important part, we check the application front to back. Once we've checked the application, we draft a letter to the DC or to the instructing attorney informing them of whatever we need, whatever is outstanding. The payslip is outdated, for instance, the proof of address is outdated, just for instance. Then we issue the application before we get the information. Now, let me just explain. We can issue the application prior to receiving the outstanding information if the application is drafted for the correct jurisdiction.
Okay.
In other words, if it's drafted for Goodwood and the consumer resides in Goodwood, we're good to go. Further, if it's a single application and the consumer in fact isn't married, we can issue the application. Small things like outdated payslips that we can address later. Okay. So now we've got the court pack, we've got the original, we've got a copy. We go to court and we issue the application. That means we arrange a court date and also obtain a case number. Once we have that, we drive back to the office. At the office, we scan the application and we serve it on all respondents. Basically, after that, we draft the service affidavit, we draft the set-down, and we wait for the DC or the instructing attorney to provide us with the outstanding information. Now, it's important. I know a lot of DCs and a lot of instructing attorneys, they assume that a day before the court date will suffice. It won't. We need the information at least 10 days prior to the court date, because once we have it, we have to check it. Then we have to attend court again to file the supplementary affidavit. We have to file the set the matter down. You have to do that 5 days before the time. So imagine if we get the outstanding information 5 days before. It's not enough, because we need to do the set down 5 days prior.
Derek, what then happens if you do get it a day before? How do you resolve that? How do you actually work around that now that you've received it and you're actually out of time?
Justin, assuming we get it a day before the court date, on the given court date, we go to court. If it's Weinberg, for instance, depending on the magistrate, we will not be allowed to hand it up, because in Weinberg, attorneys are not allowed to hand up documents. You need to file it, let's say 5 days prior. And there's a good reason for that. If the magistrate wants to go through the application and it's not in the application, then they can't check it properly. However, some courts allow us to file it or to hand it up. Some courts even insist that we do not file it before the time, that we actually hand it up in court because it gets lost. Um,
Okay,
that's
so then I
basically,
think an important question that you then ask is, what is the jurisdiction? Because that, I think, gives you an indication of, are you going to have trouble down the line or are you not?
yes, that's
Okay.
that's usually a good indication. Obviously, on the given court date, it's easy. Go to court, Your Worship, morning. It's a first appearance. There's no opposition. It's my submission, the paper sign order. If it's Weinberg, for instance, Your Worship, we filed the supplementary in respect of fees. May I approach to hand up my draft orders? That is the day in the life of an attorney or myself, my company, my clerks. Once the
Yes.
order is granted, we drive back to the office, we scan it, and we email it to everybody.
Okay. Derek, when you have to draft a supplementary affidavit, I think what a lot of people don't perhaps know is that supplementary affidavit's got to be served on all parties. Is that correct? So or does it not need to be served?
No, Justin, if we go to court, a magistrate, for instance, wants to know why the debt counsellor did not investigate reckless, assuming there's no proper paragraph in terms of section 86.6b or regulation, what is it, 24.8.2d. What we do, we will draft a supplementary affidavit on the court date. We will just hand it up. You do not need to serve a supplementary affidavit on all the respondents because it doesn't concern them. Nobody asked for that. That is a request by the magistrate. However, if there's something outstanding like a confirmatory affidavit, for instance, not even that is served. We can even hand that up. The magistrates allow us to do that. It's not ideal, but we're allowed to do that.
Okay, Derek, when it comes to outstanding documentation, so I think, if we can perhaps move down to those sort of obstacles that you sort of come across on an actual daily basis. You said that you obviously do your checks and balances beforehand. I think it's important for us to just note what are the most common issues that are stopping these matters where you get the instruction from it being smooth sailing through to court, why it doesn't get granted in the first place, why there are matters that end up getting proposed. What are the sort of general indications that you actually get that we can discuss?
Justin, what I've seen, I just want to take this out.
Sure.
The question most people want to know, what can we do? And they're looking for the solution at court.
Yeah.
The solution you won't find it at court. And it's, I've made a little list. Let me just explain. Day one, when the consumer, and I'm referring to call centers now, I'm just going to refer to a call center. A consumer phones in. Unfortunately, the call center agent is more concerned with writing the deal than taking a minute or 2 minutes longer and getting the correct information from the consumer. That is the main thing for us. What we see mostly, incorrect jurisdiction. In other words, a consumer is married in community of property. They reside in Goodwood, but the one works in Cape Town, the other one works in Simonstown. That jurisdiction is Goodwood because it's in community. They both reside there. If it's a single application, it doesn't matter either work or where they reside. Then small things like contact details. Spend a minute longer. Get all the contact details of the consumer, work, house, not neighbor, but family. If you can get 20 numbers, do it. If you can get an email address, it is extremely, extremely important. Also, how the consumer is married. Lots of times a consumer will phone in, the husband is in the Eastern Cape, and the call center agents will lock that as a single application in order to get the deal through. If it's a joint, or if the parties are married in community of property, it must be a joint application. No way around it. So in other words, if we go to court and it's the incorrect jurisdiction, we're dead in the water. The application must be withdrawn. You cannot fix that. We're dead in the water. If it's a single application and the consumers are married in community, you're dead in the water. You cannot fix that. That is the main problem that we receive. I'm just looking at a note that I made on my wall here.
Yes.
Secondly, It's interesting. We do this every single day, but I had to make a list of everything. When we get the court backs, we check the applications front to back. That is the most important thing out there to do, and that's where most attorneys and debt counselors don't understand the process. They want check your application, make sure what you need. Once we check it, we send out a PEP letter. That's a letter to the DC or to the instructing attorney to say, listen, guys, we need 5 things. So the second problem that I'm experiencing, we do not get the information at least 10 days before the time. It's either sent to us a day before the time, meaning that we cannot index and paginate the papers, meaning that we have to postpone, meaning that on a next appearance, you might find a different magistrate, or we don't get it at all. And that obviously leads to postponements and the orders not being granted.
Sure.
Then also, I know the debt counselors and all the instructing attorneys out there, they struggle to get confirmatory affidavits. So when we go to court and we receive a court back, for instance, and there's no confirmatory affidavits, we can still issue, technically speaking, these applications are defective, but we are allowed to file it later or to hand it up. Now, the confirmatory affidavits, once again, so we draft the confirmatory affidavit, we phone the consumer just to make arrangements for the consumer to sign the confirmatory affidavits. One, we can't get hold of the consumer. The consumer is gone. The reason for that, day one, proper instructions by the call center agents were not taken. They did not take all the numbers, house, work, whatever, wife, girlfriend, so we can't get hold of the consumer. Alternatively, once we get hold of the consumer, sir, we from Benderman and Associates, we've drafted the confirmatory affidavit, we explain what it is, can you come in to sign it, can we mail it to them? And once we ask whether they're married, for instance, they will say, well, I'm not single, I'm married. My husband is in the Eastern Cape. Or no, I don't reside in Goodwood. Actually, I moved 2 days ago, I'm in Simonstown now. Once again, we're dead in the water, and it all goes back to the initial instruction when they applied for debt review.
Correct. Yeah.
Can you see? I'm not touching. I'm not even close to court. I'm still at the form 16. I'm still at the application form.
Yeah. I think that even goes down to what I was saying. You know, is why are so many matters not proceeding to court? And exactly what you're saying. This is why is you can't get hold of the consumers, or now it's the wrong jurisdiction. So now you've got to withdraw. There's got to be another application filed. There's information missing. So I think what we need to take out from here, and what's crucial here is specifically that, is that there's information that you need to finalize the matter, and that needs to be received at inceptions. And what I also think, and I don't know if you agree with me, perhaps there needs to be a better prep from the debt counselor to the consumer to say, look, when we do go to court, this is what you can expect. You are going to need to get in touch with the commissioner because you're going to have to sign an affidavit, for example. And perhaps that information is not being relayed down to the consumer. I don't know if you agree to that. When you speak to these consumers, are they surprised that you do contact them, or that you are asking for this information, or are they aware of it, Derek?
They're definitely not aware of it. I can assure you what I say to a lot of debt counselors, day one, make sure that the call center agents take a minute longer and educate the consumer. You can educate the consumer in a minute or two.
Sure.
I know that for a fact because that's what we do. When we phone them for confirmatories, we explain the process, and I can assure you, it's the first word they get of it. We explain it, and once we explain, then obviously they would say, well, I'm not single, I'm married, or my husband is in the Eastern Cape, whatever. And we have to, at the end of the day, go back to court, withdraw the application, inform the debt counselor, and it's starting over all the way from start. Just something else. Yes, but I mean that's why orders are not granted. Then another reason when debt counselors make use of attorneys. When I get a new instruction, or when I get phoned by a debt counselor or a new attorney, I send them firstly a list of jurisdictions. a list for my area. So once if they see the consumer resides at Sea Winds, they will check and they will immediately know which court it is. So in other words, I believe the attorney must provide them with a jurisdiction list. Secondly, the attorney can provide them with the citations for the courts, Cape Town, Belleville, whatever courts, the citation, because you need an address within 15 kilometers from court. And then also very important, every single attorney must always have a list of court requirements. So if I get a call from a debt counsellor to say, listen, I've got a Belleville matter, then I can send them a list of court requirements. For instance, if we take Belleville Court, the confirmatory affidavit and the founding affidavit must be commissioned properly. The full names of the commissioner must be in their full names, not A.B. Smith. They will not accept it. Now, once you get to a stage where you check the application and you know your requirements, you can educate your instructing attorney or your instructing DC. And basically, they must provide you then with a proper application or with the documents. And when we go to court, I can assure you most of the orders are granted first appearance. I would say 92, 93% of my orders are granted on first appearance. On this basis, we check the application, we send a list of what we need, we go to court, the outstanding information are filed before the time, we hand up what we need to hand up, which is basically the draft orders, and the orders are granted. So in short, before the application is issued or before you go to court, the outcome is determined by the debt counsellor.
Right in the beginning.
Right in the beginning. The debt counsellor and the attorney. Once you're at court and you're facing the magistrate, the outcome is determined by the magistrate and the attorney. In other words, a magistrate will require documents or information, and if the attorney knows the Act, he could, for instance, say, Your Worship, firstly, the Act doesn't make provision. This is not what the Act had in mind. Or, Your Worship, that aspect was dealt with in paragraph 10. I see it every single day. Attorneys go to court, and I don't want to blame the attorneys because they're not to blame. I'm just saying, a clerk, a candidate attorney will go to court. The magistrate, if I can give a classic example.
Please do, yeah.
A magistrate will say, Mr. So-and-so, attached to your service affidavit, I don't see a consent to serve for ABSA Bank. You served the application on ABSA via email. There is no consent to serve for ABSA. You've got consent to serve for Consumer Friend and the other respondents, Netbank, F&B. There's no consent to serve for ABSA. The clerk will say, Your Worship, as it pleases the court, may I please just ask for a postponement 2 weeks and I'll have it. Wrong answer. Guess what? The consent to serve, there's a paragraph at the bottom of the COBs.
Of the COBs, okay, yes.
To say they consent to serve by email, it's about knowing your papers. In other words, clerks going to court, candidate attorneys, if they know their papers, they will be able to address the magistrate and educate and show the magistrate that the papers are actually dealing with whatever the magistrate sees as being outstanding.
Outstanding, sure.
Yes, you get one or two magistrates that have additional requirements. Guess what? It's not the end of the world. If they want something, a magistrate in Kailicha is a very good magistrate. I know the first day he said to me, Mr. Benderman, I see this is a single application. This lady is not married. She's got 2 dependents. Is she getting maintenance? Good question, Your Worship. Good question. But it was not dealt with in the paper. So what we do, we go back to the debt counsellor. The debt counsellor will then phone the consumer, something that they were supposed to deal with day one. But I mean, once again, once we educate them and say, listen, guys, for Kailicha, you need to address maintenance. If it's a single lady, for instance, does she get maintenance? If so, how much? Once you have that, you do a supplementary affidavit, you file it before the time, or you just hand it up and the order is granted. However,
yeah. No. Carry on, Derek.
Day one, if the information are not contained in the form 16 or the form 16 is defective, I know what lots of DCs out there are obviously saying. Well, in terms of regulation 24, regulation 24 is clear. It says the consumer must provide a duly completed Form 16 or the information. You must just provide the information to the debt counsellor, which is correct. In other words, the fact that the Form 16 is the defective, it doesn't make a difference. Well, it does. If you do not include a Form 16 in the application, then you can rely on Regulation 24 to say, well, there's no need to have a Form 16. But once you have it and it's defective, the budget or there's information on there, it says the consumer is married COP, and you bring a single application, then the magistrate is fully entitled to ask the attorney to go back to the debt counsellor to clarify that discrepancy.
Sure. Derek, thanks for that. I think, from what you were saying with the Khayelitsha magistrate, I think an important question that I think I wanted to raise here, and there are two questions that have popped up here that I will ask shortly, but it seems, gone are the days where magistrates just read the papers and grant the orders. They are now asking questions. They have now specific requirements. Is that a stumbling block, I think, within at court, where magistrates are in the positions where, I may call it that they are applying their minds to the application, but perhaps they're making absurd requests? Do you find that happening often, where they're asking for specific things and not just reading the papers and granting accordingly?
Well, in the past, a magistrate cannot read the papers. If a magistrate has or have 40 debt review applications on the roll, to read the papers front to back, there's just not enough time. So what the magistrates do, firstly, they look at jurisdiction. It's the most important thing. And then secondly, if it's a single or a joint application, okay? And they look and they check and they make sure there's a confirmatory affidavit, because Rule 55 is clear. It must be a founding affidavit and supported by a confirmatory affidavit. So they will look at jurisdiction, confirm if the consumer is married. If married, COP, it's fine. If out of community of property, you need to attach the antenuptial contract. And then thirdly, what they look at, and I don't want to speak on behalf of the magistrates, but this is my experience. Lately, the magistrates are going through the budgets in more detail, because ultimately the question is this consumer over indebted? Once again, to give an example, family expenses will, for instance, be listed as 3,000 Rand without specifying. And you will find certain magistrates wanting to know what that 3,000 Rand is for. That's a reasonable request.
Of course.
Now,
yeah.
To answer your question, do they have unreasonable requests? Yes, we find it from time to time, but that's where the attorney comes in to say, Your Worship, you know what, the act is clear. I can present you with case law. Even the task team agreement has discussed this topic. I think your request is unreasonable. However, we are dealing with more or less what you want to know in paragraph 10 or the summary proposal. And in most instances, it's like give and take. If you can convince the magistrate, and it takes the attorney 1 or 2 minutes longer, that the papers are properly drafted, the papers are in order, the court has jurisdiction, it is a single application, and whatever is required is sort of unreasonable and not what the Act had in mind, they will usually grant the orders. So just to summarize, the most delays are caused because of incomplete Form 16s and attorneys or debt counsellors not providing the requested information before we go to court.
Okay, thanks so much, Derek. I just want to go through some of these questions, if you don't mind.
No, not at all.
One of the questions are, if you can perhaps give us a summary of time frames for the notice of motion and the notice of set down. I know you know that about the 15 days, and that if you could maybe just reiterate that, if you could, please.
Very interesting. So, and when I refer to debt counsellors, because usually the instructions are from the debt counsellors, I think they see the court process as a lengthy process. It is not. To give you an idea, if I receive an application today, and I check it today, for instance, I have the copy, I have the original, I check it, and it's perfect, assuming that the instruction was given to me by a correspondent attorney who drafted the papers. If I issue the application today, and assuming that I can go to court today, I can put it on the roll for 17 August.
Okay.
Justin, that's a mere 17 days away.
Yeah.
And I mean, quicker, why? I mean, imagine I receive an application today, I can have it on the roll 17 days from today. So it's a quick process. You usually do not put it on the roll for short periods. Like if I receive an application today, I will usually not put it on the roll for the 17th, which is the first available date. If you calculate, you know, the core days, because of outstanding documents, there's usually an outstanding confirmatory affidavit, things that we wait for, things that we know we're not going to receive in time.
So the actual time frame.
In most instances, correspondent attorneys will, in the instruction letter, say, listen, do me a favor, just issue this application 3 months in advance. And that is why. So the debt counselor doesn't know why. The debt counselor will instruct attorney in Gauteng to assist, you know, with the drafting. The Gauteng attorney will, it's a Cape Town matter, they will send it to me. I issue it on instruction 3 months in advance, and the debt counselor does not know why it takes so long. So in effect, how we work it out, if you put a matter on the roll today, the court date must be not less than 10 days, court days in the future. So we usually take 13 days. If you count 13 court dates or days from today, you'll end up with 17 August. So yes, we can issue, file, serve, appear in roughly 17, 18, make it 20 days, which is 2 weeks.
And get a granted order provided you have all the information you need in the first place.
On first appearance.
On first appearance, yeah.
You know, I told you guys just before we started, many years ago, I received a call one day from the NCR. They wanted to come down all the way from Gauteng to interview me. Lengthy interview. Mr. Haupt from Justice Center was obviously with as well. And the question is, how did you manage to get 150? That was way back in 2013. How did I manage to get 150 granted court orders on first appearance? I said to them, it's my secret, and that was basically the end of the discussion. I'm prepared to share that secret today. And guys, you don't have to make notes. It's easy and simple. Check your papers day one. That's it.
Simple as that. It's literally getting everything correct the first time.
Make sure that when you go to court, that your papers are in line with court requirements. Yes, it's not unreasonable. A magistrate is not going to want the ID document on page 10 and not on page 2. They just want an application with correct jurisdiction, married in or out, single, joint, and the budget must be reasonable.
It must make sense, yeah.
And it must make sense. Basically, that is it. Just check the application day one.
Okay. Derek, another question that I received here is, how does the court apply regulations 55 and 56? How does the court apply that?
I've got no idea what regulation 55 and 56 is. I'm sorry, maybe that's a mistake.
Dawn, do you just want to maybe just perhaps post another question on that, if you don't mind, and I'm going to mark that as done. Eric,
sorry, Justin, with all due respect, I'm not aware of any regulation 55 or 56. Okay. I've never used it in all my thousands of granted court orders. I will gladly answer the question. They must just tell me what it's about. I've got no idea.
All right, I'm sure that you will post it shortly. One of the comments here, it's sort of a comment question at the same time, is where they've said that the magistrate needs to be educated on the payslip, where they need to use the payslip that gets used when the consumer signs up for the process, and not perhaps 2 or 3 months down the line. Do you find that that's a requirement where they want a more updated payslip perhaps, or does the one at inception of debt review, is that sufficient for court purposes?
If a consumer, and I'm just going to make a note while I talk, if a consumer signs up for debt review, you need to issue the application in terms of Section 8610, 60 days or not later than 60 days after, assuming 60 days after the Form 16 goes out. 60 days equals 3 months.
3 months, yeah.
We just said now I can have it on the roll in 2 weeks, assuming stretch the 2 weeks to a month. Now we're at 4 months. So to answer the question, when a consumer applies for debt review today, I mean, surely he can bring an updated payslip referring to at least June.
Sure.
What we see a lot, and I refer to these magistrates as good magistrates. They do their work properly. I would have done it exactly the same way. A magistrate hearing a matter today cannot grant an order if the payslip refers to 2019. It's unreasonable of the attorney and the debt counsellor and the consumer to expect of a magistrate to grant an order where the consumer applied, for instance, a month ago or 3 months ago, and providing the debt counsellor with the 2019 payslip. Once again, the debt counsellor or the call center agent needs to educate the consumer. The consumer is a normal person. The consumer is not a debt counsellor. The consumer is not an attorney. The consumer has a lot of debt. He approaches the debt counsellor to assist with debt. The debt counsellor needs to educate and explain. Just take a minute longer, and then the consumer will understand that a payslip is not just a payslip.
I understand 100%.
If you apply in July, give a June payslip, and that will sort out the problem. In other words, when we get to court, the payslip will not be older than 6 months. Most magistrates, if the payslip is not older than a year, which is more than reasonable, they are fully happy to grant the order on that basis, and they will not require an updated payslip. So basically, as long as the payslip is not older than a year when we get to court.
Okay. Derek, thanks. I think just to what we can unpack and sort of recap from there is your paperwork just needs to be in order. That's the crux. So instead of fighting this battle at court, have the talk with the consumer, like you're saying, a little bit longer, so that you're in a process where you've got all the information that you actually need, so that when the instruction goes off to the attorney, you're not going to have back and forth emails, you're not going to have postponements, besides those legitimate oppositions, perhaps from credit providers. But if all else fails, you're going to get a granted order on the first date. Derek, thank you so much for your information. You have been a star. I think you've given everybody a lot of, and we said it earlier, easy tips, on these are the issues that we are having, and it could be a smoother process provided all that is happening. So Derek, thank you so much for your time. We're going to just move over through to the NCT process, guys. There have been a couple of other questions that have come through. So what I will do is I will go through them at some point after, but we need to move on through to the NCT process. So joining us from the NCT, we have 3 people. We have Pranessa Mudley, who's the Deputy Registrar. And then we've got Cletabo, who's an assistant case manager. And then we've also got Bogosi on board as well from an IT perspective. So if questions get a little bit technical from the NCT process, we've got somebody that will be able to answer that, which is great. Guys, thank you so much for joining. It's great to have the NCT on board. Pranessa, I want to start with you, if I could, if you could also give us perhaps just a brief breakdown, just like how Derek did, on how the NCT process works from the time that the consumer or the debt counsellor decides to go the NCT route. What happens when that application is lodged, and how does it happen through that actual process?
Okay, thank you for the opportunity, Justin. We appreciate being here today and being part of this webinar. I will start with the process. However, I just want to give you a brief overview very quickly of where we are at the moment. The tribunal is national jurisdiction, has national jurisdiction. So we receive matters from anywhere within South Africa, and we deal with those. We deal with matters in chambers as well. When it comes to the process, we also have about approximately 28,000 to 30,000 cases that we receive each year. and we finalize around 22 to 24,000 cases each year. Yeah, so that's just us in a nutshell. In terms of the process, we have various different modes of entry, for want of a better phrase. The first mode of entry is manual filing, where a DC can physically file an application at the tribunal. This has taken a little bit of a, this has been steamrolled a little bit through the COVID pandemic, and our staff are trying to work remotely as far as possible. But on request, arrangements can be made for DCs to come in and drop these maps.
Where would they actually drop it off, Pranessa? Is there a specific address, and is it nationwide?
No. So for physical delivery, we either receive via courier or DC physically brings it to our offices in Centurion.
Okay.
However, we do accept email filings. There was a stage where we thought it would be better not to. However, we've reopened email filings. So we receive matters through our registry mailbox, which is our entry mailbox for all filings of applications. More recent, over the last few years, is the tribunals developed two other modes of entry. One's called e-filing. The idea behind it was to be very similar to the SARS tax e-filing, where physical documents be uploaded and submitted and everything moved through the process electronically. And to cater for those DCs that file bulk matters, we created an XML system-to-system ingestion of filings. So those are the four main ways that filings can come through to us. And each of it has this, once entered, the slightly different processes follow. If it's manual, obviously we don't have the electronic means of adjudicating. If it's manual, we have to adjudicate manually. So that's where we're sitting in terms of receipts. I must tell you that most of the DCs around might know that we've sent out a survey recently as well. For us, what we've noticed is that we find it a bit, if orders are getting refused, we notice that orders get refused for similar reasons. And one of the reasons would be entry into the order. So whether it be a citation issue, whether it be a, I may have deviated from your question.
No.
Yeah. So whether it be a citation issue, whether it be a issue with the input of data within a table of our order, we've tended to find those issues. So we've been looking at ways to try and reduce variety, because once entering, although our system is electronically based, it is based on someone entering data or uploading data that someone has physically entered in. And the moment you put the physical element to it, the risks or the risks of errors increase. So we have sent out a survey. We've got a new solution that we're going to run, that we're going to be running with forward, subject to the responses we get from DCs and credit providers alike. Is we going to be attaching the acceptance letters as annexes to the order. Simply by doing that, it eradicates any possibility of an error occurring in the typing of the information going into the order. That would increase the rate of granted orders versus refused orders. So that's what we're doing from our side. The error then would only come in the citation issue and legality, which from our side I've also noticed has been quite limited. Most of the issues that we have been having have been system-related issues, in the sense that DCs have been either putting in incorrect information on the system. Alternatively, the system hasn't generated the right information from there. But in those situations, DCs do come to us, and we do have a file waiver process for such, for refiling. But yes, going back to the original question, if someone files with us, the process at that point, possibly, if everything is in order, can end for the DC. On filing with us, we have we have a check on the ID, etc., etc. We do have a little check that the system does for us on the electronic filings. That check is done on the manual filings manually, obviously, taking up a lot of resources. We're actually trying to make sure we streamline our process to not be too resource heavy. And once it goes through the process, it sits on the system. It gets transferred from registrar's office, which is in charge of case flow management. That's us. So we deal with the matter from inception right until the process of adjudication and thereafter the issuing. So yeah, I think within that process, once it does go to the tribunal member has various options that it's empowered to do. It can grant an order, it can refuse an order, it can issue a directive. The tribunal has not been issuing directives. We've been either granting orders or we've been refusing orders. What tended to happen is we've previously gone through a lot of different mechanisms of finalizing matters. We've tried to stay on the pulse as much as we can. And when we realized that capacity was an issue, we found ourselves sitting in motion courts that we created in Cape Town and Durban, wherever it was. That obviously financially is not sustainable. We have moved back into our offices to deal with it and created the system. So our process flow, according to our stats, according to what we do, is an average of 70 days from start to finish. That's roughly 3.5 months. That turnaround is greatly increased based on the electronic filings. What we have had is e-filing applications have been dealt with very quickly. That you can see orders sometimes between 15 to 20 days on e-filing matters. XML matters, there's been certain matters that we're still discussing that's sitting on the system from last year that we had a certain issue on. Those are taking longer, dragging up the turnaround, for example. The XML that's been filed this year has been moving faster. Manual filings have been very slow. And the reason for the slowness initially was the power was not with us on a manual application, which I think was a real fault on our side at some stage. We required through the motion court process for a DC to take a further action. So they filed the application with us. We required a further action where they put a case number in the order and they resubmitted for that order, particularly for adjudication. The reason that that XML and e-filing process is our go-to process is because we do that ourselves. So we become in control of the entire process, whereas on the manual side, we tend to lose the process a little bit. So really on a manual side, it's very dependent on a DC. However, with manual, there's errors. Anytime there's manual filings, there's going to be errors. I mean, we're working with 28,000. We unfortunately do not have venues at each direction, each jurisdiction or each different area. We do not have staff sitting at each area. So the volume of cases that we receive in one base needs to be managed. And there is difficulties that would come through to it because of the sheer volume that we're dealing with. However, on the system matters, volume becomes less of an issue. In fact, the more volume that we receive on the system, the much better it is in terms of our processes, our ability to be dynamic, our abilities, you know, to be flexible to and adaptable to the situation. The manual applications do slow us down a lot.
Pranesen, if I can just interrupt you there, if you don't mind, what is the sort of split in the numbers of people that are still submitting manually versus those perhaps online and the e-filing route?
Okay, over the last few months, it's been very hard to really give you a proper figure, considering that people have been more reliant on e-filing and XML as opposed to manual filing through this COVID crisis. Before that, we did find that the split was even 50-50 manual to electronic, and that split has gone a little bit better towards electronic and e-filing cases through this COVID pandemic. However, we still do get manual filings. Some DCs prefer it. They find that the chances of them getting a granted order is higher with the manual filing.
Is that the case?
At the moment, I think there's some difficulty with filing the electronic filing in terms of the e-filing, and it's mainly due to data input. But what we've done to try and prevent that, we've created a template, and we've done this for some time now. We created a draft order template that a DC must confirm before they submit. So if, for example, they capture all the information in, they have the opportunity to look at the order, verify if that order is exactly what they wanted it to look like before moving it forward. But I have found that more e-filing and electronic matters have been refused, and I think mainly there it's maybe that functionality wasn't being used, or there might be some obviously some misalignment between our tribunal expectation versus the DC expectation of what needs to be provided. And I mean, that's why we're here as well today. If we can try and reduce the levels of misalignment, that would be a benefit for us today.
No, it would be. Professor, one of the questions that have come on is to ask, of the 22 to 24,000 matters that have been finalized, what percentage of those would have been refused applications due to the member exercising their discretion? Would you have those stats on hand, or perhaps share them at a later stage?
So I can tell you this much. In our history, we've refused 1,800 applications, and that's talking from when we started debt review in 2006. Right to date, we've refused about 1,800 matters, and I think we've received about 150 to 160 thousand matters. So the percentage of refusals are very low, but the volume of refusals that we received more recently is very high in comparison to that. In terms of what the particular basis for the refusal is,
Yes.
I can only give you like a view. I don't have stats to that effect, but I can only give you a view. And what I noticed from most of it is citations have been one of the big reasons for refusals. For us, citations is crucial. We need to know that the right credit provider has been listed in the order. We do not want an order where a credit provider is not properly cited because of the consequences of that, the obvious consequences.
Okay. Vanessa, if I can just interrupt you there, when it comes to those incorrect citations, how do you sort of validate that it is an incorrect citation and that you request for them to actually correct it?
Okay, so we can't actually physically check if this PTY exists under this name, but we can be 100% certain that Nedbank is not a sole prop or a partnership. So that's where we exercise some of the discretion. The tribunal member exercises some discretion.
Okay. Vanessa, one of the questions, and again, this is for any one of the panel members, is a question that has come in to say is, why is there no allowance for correction of errors instead of an outright refusal? So it's almost as if, you know, the matter's got to be refused and then a fresh application's got to be lodged with the corrected information that has been asked. Is there perhaps something on the cards or a reason as to why a matter can't be in effect postponed, if I can call it that, so that it can be corrected and then refiled?
So we adjudicate in chambers. The issue of the directive was always carried out in a form of a correction before. The reason why we trying not to do that is, if you look at the numbers, the sheer numbers that we have 28,000 cases. We have matters that we deals with most sections of the CPA and NCA, which covers 10 to 12 days of our working month. The balance of the days we spend dealing with DRS. The volume of tribunal members that we have to adjudicate is, I think, 16 or 17. It's for all matters across the country that come to us. If we have to continue doing corrections, we've noticed that we don't only do one correction with the matter. So in effect, eventually what we would be doing is double and triple adjudicating and taking our cases and taking the matters more far forward. The assistance that we provide tries to get the order to be granted. We've got our IT unit that does live webinars. Our case management does, not webinars, Zoom sessions. Our case management unit does that all the time. The idea is we also allow for test applications to come through. We need to get these things correct because we don't want to be double adjudicating and even triple adjudicating on the same matter.
Okay. Vanessa, I just wanted to chat to you about a process perhaps at the actual NCT when it looks at the time frame. So you said that you know it normally takes about 2 or so months, 2 to 3 months for a matter to get resolved. Do you think, or how do we get consumers or debt counselors to use the electronic process over and above the actual physical logic? Because I think that will also reduce the number of waiting time periods as well.
Yeah, so I think the new process that we're going to implement is going to be great for that. The reason we're implementing it, yes, the reason we're implementing it is because there was a lot of benefit that came to us on the XML. A lot of feedback we got from DCs. There's a lot of benefit that comes to us on XML and e-filing process. However, there was a lot of work that they still had to do from their side. And we thought about it, and we were looking at ways to try and reduce the burden that they have. The new system is not for our benefit. This new idea, or this new way of dealing with things is not for our benefit. It's part of us trying to implement a good change management process to allow the DC to do as little as possible to get as much as possible out of its application when filing with us. So I think that naturally, if matters start getting finalized faster, because it will also could possibly double our adjudication time, the matters that we're going to adjudicate on per day, for example. Possibly you'll find turnarounds going faster, you'll find errors being less, and you'll find DCs being happier with the process as well.
Yeah, yeah. Where can debt counselors get more information on training or documentation regarding this new platform for e-filing? That's just one of the questions that have come up.
I've got two colleagues here, and I think maybe they might be in the best place. They do deal with the training aspect, and I believe they would be able to answer that.
Okay. Letabo, I don't know if you want to maybe just touch on that, where debt counselors can perhaps get some information on training or some documentation that they can look through on how this process works and how they can perhaps get it going with the NCT.
Hi, Justin. Thanks for the opportunity. Yeah, with regards to training on our side, the case management side, we do mostly on circulars that we have. These are circulars that have been sent to debt counselors. The circulars that are provided on our website, and we do have, upon request, maybe if a debt counselor would want one. But the normal process is that an email would be sent to our registry email, in which a debt counselor would be requesting training, either for guidelines on filing in terms of what types of documents are needed, or on the e-filing process, which our IT assist in that department, because they give them a rundown in the process and show them everything in terms of signing up for our e-filing. And then we usually circulate amongst the staff to do the training, but we do training on Circular 7, which is the basic guideline, which will just list all the documents that are needed in a 138 application, which is a debt review application. Things like your ID, your proposal, and acceptance letters, and power of attorney. We also do on a power of attorney circular, because sometimes we would get instances where powers of attorneys are not adequate in terms of the standard which are set in the circular, like maybe they aren't signed by the debt counselor, or the debt counselor isn't specified, or sometimes it would only indicate one consumer where people are married in community of property, things like that. But we do also have a circular which specifies exactly what is needed in a power of attorney. And then we also do training on Circular 8. It's not so much of a training, it's just a rundown and explanation in terms of, it goes with the question, I guess, that Pranesen just answered, which was posed for why are there no longer corrections issued for applications. So it basically just touches on everything that he said, because it did become a process in which, you know, we have to re-adjudicate a lot on the same application, which is a bit of a backlog and it's a bit of a mess. But yeah, we do training on that. And
okay, great. Okay, so should the debt counsel just sort of touch base on your website, and they'll be able to get all of the information on there. If you guys, are there perhaps other contact details that debt counselors can perhaps use just to touch base with one of you, perhaps if they just need perhaps more in-depth questions answered? Would you be open to that?
Let me answer that. You can use my email address. It's pmodley@the.nct. You guys can submit it through. Yeah, case flow and anything to do with case flow can be emailed to me, and I would forward it through to the relevant persons.
Okay, perfect. Thanks. What we will do, Pranesen, is we will also just share this with the actual attendees after. Another question that's come up, Pranesen, is how do we rescind an NCT order?
Okay, so rescission. A rescission of order is done through 165. There's 3 grounds only to rescind the order. 3 grounds off the top of my head, can't recall, but there's 3 grounds to rescind the order. For example, not done in the presence of the other party. There's an error that's contained in the order that was obvious to each other. Things like that. Only these 3 reasons. There's no other way that we can rescind the order. When rescinding it, it falls part of something we call non-DRAs. Non-DRAs for us is not debt rearrangement, it's hearing matters. It follows a process of you manually file it via email or physical delivery. We assess it, we do a tough screening process on the case. That is something that has been sometimes regarded as a barrier to entry for us, but we do the screening in the case because very often we find that there's a very unnecessary issue that has resulted in an order being refused. So we rather take the time in the beginning to deal with that. So we do a strong assessment, 15 days for answer, 10 days for reply. We close the pleadings, set down the matter for hearing. We do all of it. You file the applications. We give you a set down date. During lockdown, we've been very slow on non-DRAs, I must tell you. We haven't been dealing with much of it. We've now started again, but we're also limiting the number of hearings. Before we used to do 5 on a day, 4 to 5 on a day. We are trying to do 1 to 2 on a day as a maximum because we really do not want to risk consumers and everyone coming through to our offices, especially since we have national jurisdiction. We're using facilities like Zoom as well now, but there's certain requirements that people need to have, which is also sometimes regarded as a barrier. We're working on ways of fixing that as well.
Okay, great. I see one of the nice comments that I've seen here is that they're saying, one of the panel members are just asking, you know what, maybe it'll be nice for the NCT at some point to look at perhaps arranging a webinar on a training session, perhaps taking debt counselors through covering perhaps certain topics. So that's maybe something that you guys can actually look at, you know, perhaps within the near future.
We do, Justin, and I think this is one of the biggest things though, is we only have a database of who we have. And it becomes difficult because we want to have these training simply because the tribunal we don't share the same jurisdiction as a magistrate court. We only deal with matters where consent is granted, but we would like to have all the matters where consent is granted come to us. And we don't. I can confirm that we literally have 250 DCs filing with us. And that is shocking considering the amount of DCs that there are available. And yes, it's through some problems. I see there's a comment there about waiting since October 2019. Please just forward me your email. You get my email, we'll follow up on it. So, you know, worrying about these sort of things, we want to get more DCs to come to us. The only way to do it is to improve and make our systems more efficient. But also we don't have the contact details to contact them. We try to rely on the NCR database as much as we can. We do it, we get entries where we've had webinars holding 10 people when we invited 1,900 people. You know, whether it's not going through to DCs, whether we need to find better ways of getting through to them, but we really want to have these webinars. It's really going to help us because we rely on it.
All right. Okay. Well, look, I'm pretty sure we can put ourselves out there as a sort of channel point as well. You know, when you do have your next webinar, please, you know, feel free to touch base with Shannon and myself, and we can obviously try and just spread the word as well, just to get as many people on board.
Thank you.
Okay. I see one of the comments that have come up is when a question is asked or a query is sent through with regard to a long outstanding matter, it seems to debt counsel that the only response that you'll get is, you know, it just hasn't been heard yet. There's sort of nothing more to that. I'm not sure if you can perhaps answer to that or maybe comment on that or perhaps give a more in-depth, maybe reasoning to those debt counselors who have been waiting for longer time periods.
So yeah, I accept that. We do have queries that come through like that, but how we deal with our matters, unfortunately, is we try to look at our oldest matters and send it through for adjudication. We constrain on a few things. We have 16 tribunal members who is, half of them are not always available. You know, they'll be available half the time and not the others. That's why they're part-time. And what we do is our process says we've got 8 tribunal members available for today, for example. Each member can do 40 matters a day. We can only allocate that 320 matters. So our process results in how we adjudicate to them. It's difficult. Sometimes I do find that we do give responses that says, listen, you will be next in the queue. We currently on this date. at the moment, you know, but because we have different filing mechanisms, it's also difficult to give a date because e-filing, we're very up to date. Manual filing, we're very not up to date. XML, we're up to date, but we're also not up to date on certain matters. You know, so it becomes a bit difficult on our side, but if there's queries, and please know, it's just that there's nothing we can physically do anymore, save for wait for availability and give the tribunal member the matter to adjudicate on.
Okay, thanks so much. Brilliant. And I think, you know, just gauging from you guys, I think it's the sort of obstacle that the NCT is actually experiencing is pretty much the same as what the attorneys experience at Madge Court, is that the documents or the forms that have been filled in isn't necessarily got the correct information. And that's also stopping matters from being granted and getting an Nct order in place. So do you just want to perhaps just touch on those sort of, you know, just before we end, is on those important things that you see that is not being ticked off, that needs to be included, the most common things that do come up, that we can maybe get debt counsellors to address that at inception so that you don't have to refuse an order in the first place?
Letabo, do you want to take that question?
Sure.
Can you just rephrase it? I'm having a bit of a connection issue here.
Yeah, Taba, what I was saying is that I think the obstacles that the NCT faces in getting an NCT order granted is very similar to the obstacles faced by attorneys, in that you don't necessarily have all the information correct at the time that it's being assessed. What are the most common scenarios that you find that information is not being correct or is missing from an actual application that causes the matter not to be granted?
Yes, it's correct. We do face similar issues as the attorneys regarding the Magistrates Court, in that a lot of the refusals, I know the trends that we notice a lot, it would be because of small things like the ID document is illegible, but mostly with e-filing, it is the capturing. Because sometimes DCs do get a bit mixed up, or there's confusion in terms of cascading payments and concession periods and all of that, because tribunal members do take it literally as is in the acceptance letters. So if the acceptance letters doesn't have that information, but the DC types it up, you know, according maybe to the proposal, those are things that do cause a lot of refusals. And then with manual filing or manual applications as well, it's more errors like consents or acceptance letters. It is very document orientated. It doesn't have a lot to do with the process on our side. Very few times you'll get, maybe because of the interest rate is not according to provided legislation. But yeah, we do face quite similar problems, or face similar problems as the attorneys.
So I think what's key that we need to note from this discussion, and this is both the Madge Court and the Nct Process, is that the data, I think, supplied at inception of that instruction, whether it's at Madge Court or at the Nct Court, is paramount. Is that I think debt counsellors also need to understand the actual timelines and also the documents that's needed and the information that's also needed, so that when that is filed initially, you're not going to have a situation where matters are postponed, or in the case of the NCT where they are refused because perhaps the citation is missing, for example, or is incorrect, or perhaps there's documentation that was supposed to have been supplied that hasn't been supplied. So for this entire legal process, you know, this consumer's gone through this whole process of being under debt review and you know, with the proposals being sent, for him not to get the final order on a silly situation where it's based on data that's just not missing is, you know, that shouldn't be the case while matters aren't being granted. You know, there should be the bigger scheme of things. You know, we shouldn't be dismissing matters because something isn't filed properly. So I think what everybody needs to take away from here specifically is that we need information at inception. So the most up-to-date information that DCs can get from their consumers at inception, so that you don't have a fight later on down the line with regard to outstanding information or data that's actually missing. And I think that's going to be paramount in changing how quickly matters get granted as well, because they're not being postponed. I think that's what I take out from this conversation as well. Final comments from your side. Praneshan, I know we are running out of time. We can speak for another 2 or so hours on this, but is there any closing comments that you maybe just want to chat to on your side on this actual topic?
Yes, there's just one. I just saw a comment that I thought I could address.
Sure.
One of the questions was to do with wouldn't we be slower in adjudicating if more DCs join, like I'm suggesting, which is a very reasonable question. Yeah, I thought I could answer that just by explaining why I say that. It's capacity is an issue, but remember we government funded. And because we government funded through Corona, through all of these things, through general views of public, our funding is not unlimited. One of the organizations which is quite small, I think we have 40 staff to deal with the whole of the country's work. And it is a problem. But that being said, once matters, DCs file more matters on e-filing and more on electronic filing, it allows our contribution eventually to increase. And it gives us the capacity and the flexibility to be faster. So it's actually the converse of what's going to happen, because all of a sudden we'd be sitting with being able to access a second stream of revenue that would allow us to be faster in our adjudication. You know, so currently we have a lot of inhibitors that will allow us to be much faster. I mean, that's our aim. We want to be faster, but there's certain things that's holding us back. Filings are one of them that can really make us a lot faster, irrespective of this, especially with the new system where we can double up our adjudication time. Because I've told you that we can do about 40 cases a day. We're proposing that we're going to do 100 cases a day. We're proposing that we're working for 10 days a week dealing with this matters. Each tribunal member can do 10,000. Each tribunal member can do 1,000. We'd be using 10 for the month. That's 120,000 is our capacity availability if we can get to that state without increasing the turnaround. You know, might be reducing it even. So that's where we're sitting at the moment. So we do have capacity, we can do more, but it's all a mix of functionality versus finance versus this and versus that.
Sure. Praneshan, thank you so much for being on board. I just want to unmute Derek if I could. Derek, do you have any last comments perhaps on your side? Just as sort of finalization, I think what we can take from here is that I think both processes are experiencing the same issues. From that, is there just maybe there's the last comments from your side before we end off?
Justin, maybe a misconception. I think most people think a debt review application is won at court. You don't win a debt review application at court. You win it at your office. We count our debt review orders before we go to court. Just to give you an idea, we know what the court wants, what the courts want. As long as we get the information, I can go to court and I can tell the magistrate, the papers are in order, may I approach to end up my draft orders. So it's not, you don't win it at court. You do it at your office before you go to court. And then I hear the NCT inviting debt counsellors to support them with work. Our capacity is endless from a attorney's point of view. And one last thing, you know, there's a lot of training for debt counsellors. I don't see a lot of training for attorneys and candidate attorneys. I think if we spend time doing that, it will also expedite the process, because I see it in court. Mostly candidate attorneys attend court, and you've got the candidate attorney facing the magistrate. Whatever the magistrate wants ends up in a postponement. Usually because the candidate attorney is insecure maybe, or not all that up to date with the papers. That is something that can be sorted out in no time. So I think the process, the court process, is just misunderstood. It's not, whatever goes wrong is not at court. There's no need to blame the magistrate. It's actually going all the way back to the initial instruction. And we're not blaming the consumer. We're saying the consumer needs to be educated by the debt counsellor, who is the expert. And I think that summarizes the whole process.
I think so. Derek, thank you so much. I think, you know, just to reiterate from our side, I think the ground that we've gained here is to get the affairs in order before it becomes a problem. I think if we can get all that information, this is both for the Magistrates Court as well as for the NCT, is that we get, the information beforehand, so that it's up to date, so that when you are ready to go to court, your information is not there. You're not running to look for the consumer. You're not able to get for the consumer because you've got the updated details, etc. So I think that's all we're going to have time for today. I just want to say a big thank you to all our panel members. You guys have been awesome. I think we've shared some nice information with everybody. I think everybody's perhaps a little bit have better information with them now. They can try and get things done, hopefully a little bit quicker. And I think also it's just opened up some dialogue with us. I think if debt counsellors and attorneys work closer together, if the debt counsellors and the NCT work closer together, I think we're able to sort of finish this whole debt review process a lot quicker and easier towards the final stage of that. So I just want to say thank you to you guys for that. There have been a couple of emails that we haven't been able to answer. There were some that I actually looked at, and I think it just requires some of our members just to apply their mind to it a bit. So what we'll be doing is, just like the first webinar, we'll be circulating all the questions through to our panelist members. And what they'll do is they'll be able to look at that and answer it on there so that you have it on paper as well. There have been some requests for contact details and that, and I'll obviously just get the go-ahead from our panel members before I share them. People don't always get so happy to share phone numbers and email addresses, but I'll get that go-ahead before the time. And then what I would just like to do, just to end off, is just to encourage the debt counsellors out there just to go onto our website and our LinkedIn page as well, and just click the like and follow button, because that will also keep you up to date and abreast with any webinars we intend having in the future. Thank you so much for everybody participating in the polls. Just before we end, it'll be quite nice to go through these polls just quickly. So one of the polls that we actually came up was, which process do you use? And by far, 39% of the people that voted, I see there were a couple that have abstained, even though I requested not to, but be that as it may, it seems 39% of people use the NCT, use the Magistrates Court rather. We have a 50-50 split, so it's about 18% or so of debt counsellors that use both of the actual avenues, and then I would say 23% are more NCT process and 16% more Mag Court process. So it's really just a split along the sides. I'm going to go through to the last little poll we did, where we just asked, how long in general do you wait for a matter to be granted? So I think the most popular one in terms of the Mag Court is within a month or two. And Derek, that speaks to what you're saying. If your paperwork's correct, you get it straight away. You don't
Yes.
have to wait 3, 4, 5 months down the line. And the NCT, from the time frame of what experience, by far majority is showing a 2 to 4 month waiting time period, which is in line with what you're saying, Praness. And there's about a 3-month wait. So there are obviously ones where it gets granted a lot quicker, and some that are a lot more. But it seems like the stats that you guys are giving us is exactly what the debt counsellors out there are actually experiencing. So I'm just going to end off and say thank you so much to our panel members again, and also just a big thank you to Shannon, our marketing manager, and the IT crowd out in Durban who make sure that this works and there's no gremlins in the system. Thanks so much to everybody there. And we will be in touch with you with our next webinar, probably within the next 6 or 8 weeks. And we'll take on board the poll that you said on what you would like to discuss going forward. And we'll be in touch within the next couple of days, just giving you a link to this actual video that you can share. It'll be on YouTube as well, so you can send it to people within the industry for you guys to look at. And then we'll also pop you a mail just to recap the questions and the answers that we've been given here, so that you have it on writing as well. So thanks, Derek. Thanks, Pranessa. Thanks, Atabo. Thanks for so much for your time. I really appreciate that. And we will chat soon. So goodbye to the debt review world from Consumer Friend. Thank you so much.
Thanks.
Cheers, guys.
Bye-bye.